Hi, this is Michael Ward, partner of Elliott's Accounting, talking about estate planning. Part of being financially well organised is to have an estate plan. Estate planning is about having a plan to deal with your net assets in accordance with your wishes in the event of your death. Your estate plan is dealt with by making your will, which should then get reviewed regularly to account for changes in your life and circumstances. Your will only covers the assets owned in your own name. However, you may also control assets held in a trust or company. I will come back and talk about this a little later. Your will does not cover assets owned in a company, superannuation or a trust. You need to ensure the right people are in control of these assets to ensure your estate is divided as you would like it to be. A will ensures your estate will be dealt with according to your wishes. Your will can place a protection barrier around your assets, so you lessen the risk of your assets being controlled by those you don't want controlling them. Your will can provide significant tax savings to your children or grandchildren. Earlier, I talked about that you may control a trust. The most common type of trust where people hold assets is a discretionary trust, or more commonly known as a family trust. If your trust owes you money, either as a loan or from a previous year's income distribution, this amount will be included as an asset in your name and will be covered by your will. However, the other assets of the trust will not. You may well control a trust by being the appointer. The appointer is the person or persons who have the ability to remove and appoint the trustee. It is critical that the appointer position is addressed in your estate plan under your will and in the trust deed itself. You may also control a company by being a major shareholder. If you own a company or are a shareholder of a company in your private legal structure, only the shares held in your name can be dealt with under your will. If shares in the company are owned by a trust, you must consider who will be in control of that trust. Ultimately, it is the shareholders of a company who hold the power. When you pass away, your executors are not automatically appointed as directors. You must therefore consider who will be the shareholders. The shares owned by the deceased form part of the estate and can be left to beneficiaries. Most people's wealth resides in their home and superannuation. However, it is a common misunderstanding that wills cover your superannuation. This is the case if the trustees of the superannuation fund decide to pay out the superannuation to the deceased estate, but this isn't always the most advantageous strategy for the survivors and cannot be guaranteed. It is the trustee of the fund who decides which dependents receive what amounts, if any. The only way to ensure the trustee of your superannuation fund pays your superannuation benefits to your estate or to those dependents that you choose is if you provide a written binding death nomination to the trustee. This document binds the trustee to pay out the distribution in accordance with your instructions, which may be to your estate or directly to your dependents. A binding death nomination must be made with caution, and you must consider all aspects of your estate plan, as this nomination could actually restrict other planning opportunities, which might be relevant to your family at the time of your passing. Most binding death nominations are only valid for 3 years. If you are a member of a self-managed superannuation fund, you are required to be a trustee either individually or as a director of the trustee company. You must consider who is going to be in control of the superannuation fund after your death, so you need to ensure the correct executors are appointed, or by leaving the correct amount of shares in the trustee company to the right beneficiaries. Owning your life insurance policy in a superannuation fund is an efficient strategy from a tax and estate planning perspective. In many instances, the surviving family members will rely on this money for income or to pay debts. If these policies are owned in superannuation, you rely on the trustees of the fund to make the right decision in distributing these funds. Often these life insurance policies are owned under a separate fund to the superannuation fund where the member or their employer makes contributions. In this scenario, there would be 2 different trustees who make individual decisions about where to pay out these benefits. In some instances, it makes sense that if there are proceeds in excess of what's required to clear debts, these proceeds should stay in your super and the surviving spouse draws a pension. Pensions are tax-free for over 60-year-olds and the earnings in the fund are also tax-free. For under 60s, The pension is taxed at normal rates, but the recipient will generally receive a 15% tax rebate. The tax saving can have a significant impact on long-term returns and capital appreciation. Too often you hear stories about children losing their inheritance to subsequent blended families, or when a child divorces, their spouse receives half of the inheritance. Where a de facto relationship exists, there is sometimes the opportunity for the de facto spouse to access an inheritance. A common way of providing some protection to your assets is via a testamentary trust, which is established under your will. The concept of a testamentary trust is that instead of a beneficiary receiving their inheritance directly, the inheritance is owned under a trust. Some of the advantages of a testamentary trust are the assets are not distributed directly to the beneficiary and therefore may not be exposed to creditors and family law claims. You can ensure assets are maintained for a beneficiary, however it is not appropriate for the beneficiary to control the assets. Another person can do this. Where minors, being under 18 years of age, receive an income distribution from a testamentary trust, this income is taxed as if the child was an adult. This can result in significant tax savings on income distributed to children under 18 years of age through a testamentary trust. The beneficiaries of the trust can be as broad or as limited as you require. The rights of beneficiaries can be tailored to your situation or requirements. For example, a spouse of a child can be eligible to receive income distributions but no capital distributions. They can also be excluded from acting as a singular trustee of the testamentary trust so that upon the passing of the child, the assets can be protected for grandchildren. Any future spouses of the child and their children or stepchildren can be excluded as beneficiaries. Remember, when preparing an estate plan, cover all aspects of your financial structure as your will can only deal with assets in your name. Ensure the right people are in control of your assets and the entities that own them. Ensure your will is prepared by a suitably experienced estate planning lawyer and considers all aspects of your financial affairs in developing your estate plan. If you want to ensure your estate plan addresses your wishes and protects your family and become financially well organised, call Elliotts today on 07 38 333 999.